Mr. Dean of the Law Faculty of Thessaloniki, dear colleagues, dear students, ladies and gentlemen, today we are very pleased to welcome our colleagues from France, Professor Frederique Ferrand, Professor at Université Moulin, Lyon 3, Professor Lucie, Professor at Université Paris 2, Panthéon-Assas, and thank them for participating in the International Conference of Thessaloniki. I would like also to thank our colleagues and friends from the Law Faculty of Athens, Professor Dimitrios Tsikrikas and Professor Jiannis Delikostopoulos, and of course, the new generation of proceduralists, the Assistant Professor Anna Plevri and Dr. Anastasia Vezyrtzi, who are going to participate with their comments. I should also thank the Dean of the Law Faculty of Thessaloniki, Professor Panayiotis Glavinis, for his willingness to preside the conference. It is the 6th International Conference of Thessaloniki, organized and edited by my colleague, Professor Georgios Diamandopoulos, and me. It is true that the choice of the topic cassation could lead us to no other legal order, but to the French one, since the Greek code of civil procedure on cassation has been modeled on French law pour cassation. Last but not least, I'd like to thank Surplus Publications for organizing this conference and for bringing the 6th volume of the series to publication. And now I give the floor to the Dean of the Law Faculty of Thessaloniki, the President of the conference, Professor Panayiotis Glavinis. Thank you very much.
Thank you so much, Professor Makridou. It is really a great honor for me to chair this panel of high-profile professors of civil procedure in Greece and France. It is really a pleasure to welcome such learned jurists from French universities in this panel, and to engage in the comparative approach of the cassation in both jurisdictions. I want to congratulate Lyoka and George for having organized this for so many years now, or these panels actually, which is a big success. Thank you very much for being here. We shall listen to your to the speakers, and I would like to give the floor to Madame la Professeure Frederique Ferrand, Professor at Moulin, Lyon 3, and honorary member of the Institut Universitaire de France. Madame Ferrand will talk about the distinction between facts and law on cassation, the evolution of the control exercised by the Court of Cassation under French law, of course. Madame Ferrand, you have the floor.
Thank you very much, Mr. Dean. Thank you for inviting me to take part in this conference on a very, very interesting topic. I will share my PowerPoint with you just now in order to start. Does it work? Can you see the PowerPoint? Let's start now with the introduction. Just to remember a few important historical dates: Revolution, French Revolution in 1789, and the cassation model, which existed before and during the Ancien regime, remains, and the Tribunal de Cassation was established in 1790. The initial purpose was to sanction, to quash decision which infringed statutory provision, because the law was the most important source, of course, and the only source of law. In 1804, the Tribunal de Cassation is renamed in Cour de Cassation, and at the same time there is the famous Code Napoleon, our civil code, and its Article 4 law requires the judge to give judgment, even if the statutory provisions are silent, unclear, or insufficient. And these articles largely open the path to judicial interpretation of legal provision, and in some cases to the creation of norms, which was previously not the case because it was stated that the tribunal de cassation had to apply the law, to control, to scrutinize the application of the law, but not to interpret the law. This was done until 1835 by the parliament. I move now to the classical distinction between facts and law. And of course, one of the most important provisions in French law is Article 604 of the Code of Civil Procedure, which states the appeal in cassation seeks to have the Court of Cassation sanction the non-compliance to legal rules of the judgment it is challenging. As you can see, it is very, very broad, very open. One can understand this as meaning any infringement of a legal rule can be subject to an appeal in cassation, and this remains that way. In 1879, the expression legislation, loi, was replaced by règle de droit, legal rule, which is much broader, as you can see. How is this distinction implemented in French law? I would use two main characteristics. I would say it is very fluctuant and flexible. There is a second provision, which is also very important. I just put this on the slide, the Code of Judicial Organization. It states the Court of Cassation rules on appeals in cassation against judgments of last resort. And the very important sentence is, the Court of Cassation does not deal with the merits of the case unless otherwise provided by law. This is very important because it means first that the decision given by the Court of Cassation only deal with the legal issues, which are raised normally by the cassation proceedings, what I would call a pure legal review, no factual review, of course. And the second consequence is that the legal issue is decided on the basis of facts as found and assessed by the lower court. However, it is very difficult to say there is an intangible boundary between law on one side, subject to review, and fact on the other, which would be left to the finding and assessment of the lower court. So I would like to give a few examples of tendencies. Some tendencies which show that there can be a reduction of the legal norms under control, under review, or an extension by contrast. And I wanted to mention two very important rulings, which in my view, bring the Court of Cassation to reduce its scope of scrutiny. The first decision was given by the Plenary Assembly in 2006. It was a reversal of case law. And as you can see, the Court of Cassation ruled that the applicant has to present at the time of the first proceeding, the first lawsuit relating to the first application, all the legal pleas which he or she considers to be of such a nature as to justify the application he brought or she brought. This is called principe de concentration des moyens in a single lawsuit, not necessary in the first instance, it can also be done in the second, but in a single lawsuit, let's say. And under the wrong veil of res judicata, the Court of Cassation decided that it would not be possible to bring a second lawsuit under new legal grounds. And I think, of course, it reduces the scope of the scrutiny of legality by the Court of Cassation. Linked with the second ruling of the Plenary Assembly, too, also very important and controversial ruling of 22 December 2007. Some of you probably know we have a very important provision. It is Article 12 of the Code of Civil Procedure, which reads as follows for the two first paragraphs. The judge settled the dispute in accordance with the rules of law applicable thereto. And he or she must give or restore their proper legal characterizations to the disputed facts and deeds, notwithstanding the denominations given by the party. When one reads this, one understands that the civil judge has a large duty to apply the proper legal rules ex officio if necessary. And in that decision, the Court of Cassation, as you can see, ruled that, of course, Article 12 requires the judge to give or restore the proper legal characterizations to the disputed facts and deeds raised by the party. It does not require the judge, except in specific cases or for specific rules, to change the name of the legal basis of their claims. And this, of course, leads to a very severe restriction of the judge's duty to apply, if necessary ex officio, the proper legal rules to the dispute. And if the judge has only a limited duty to do so, consequently, the legality review exercised by the Court of Cassation is also restricted, since it cannot blame the judge for not having performed an obligation which he or she does not have. So the Court of Cassation, through that way, in my view, limits its scrutiny. There are, by contrast, trends towards an extension of the norms under review. And it is not very clear to give all the situation in which this can happen, but have just mentioned three very exceptional cases in which the Court of Cassation accepts to review the interpretation of juridical acts, such as contracts, what she normally does not do. It is first when this act bears very serious legal consequences, such as an act which abdicates a right. This is, of course, with major consequences, and this can be checked with regard to the interpretation by the Court of Cassation. The second example is where there are standard clauses, of course, the standard form contracts, what we call contrat d'adhésion. They, of course, may give rise to mass litigation, and the Court of Cassation can, of course, accept and decides to accept to scrutinize the interpretation of such clauses of large impact. And the third example is, in the same vein, collective labor agreements, because, of course, they also have a very general scope of application, which could be compared with statutes of decrees. And in such situation, the Court of Cassation scrutinizes the interpretation, although she normally does not check the interpretation of contracts. Of course, with regard to fact-finding and assessment of facts, the rule is what we call pouvoir souverain des juges du fond. This means that the Court of Cassation cannot assess the evidence and review the findings of fact of the challenge decision. If a party would try to rediscuss this, it would be inadmissible. The plea would be inadmissible. It very often happens that the Court of Cassation says, no, this is mixed with fact and law, and this cannot be discussed again before the court. In the same vein, the court cannot order new evidence. There are a few exceptions, but I have no time to deal with them. Maybe we can come back to this issue. A very important point is of course, what we call the legal characterizations of the facts, la qualification juridique des faits. This is really this hinge, between facts and law, because you have these two main parts: what is law, what is application and scrutiny of the legal rule, and you have the facts as assessed by the lower court. But the qualification des faits consists in scrutinizing whether the judges have correctly applied the legal statutes to the facts at stake. And in this respect, there is, of course, a great freedom of the Court of Cassation to decide whether she wants to exercise this scrutiny or not. First, it is totally free to define the cassation grounds enabling the access to the court. I will come back later very quickly to this point. What legal characterizations it intends to review or not. This may, of course, change over time, but there is no theory we can develop and explain saying this is checked, this is not checked. There is a control, a scrutiny of this legal characterization or not. Therefore, I would say there is a selective scrutiny in respect of the legal characterizations of the facts. I have mentioned a few situations. For example, when you have legal concepts related to psychological state, insanity, common will of the parties, so psychological issues, for example, or when it is about the fault in divorce proceedings. It is so much linked to facts that the Court of Cassation says, no, I will not check whether the facts as assessed are really legally correctly characterized by the lower court. By contrast, if, for example, there are new reform acts and new legal concepts, the Court of Cassation can decide to exercise a close scrutiny, at least at the beginning, in order to be sure there is a secure and uniform interpretation of these concepts, and then later on decide, well, my scrutiny will be maybe not so close because it is no longer necessary. It has also happened in several cases where the Court of Cassation decided no, just a light scrutiny on these legal characterizations. And then the social chamber, in one case, it was about the legal concept of harassment and the legal characterization of facts under this concept. And the Court of Cassation has seen that there were divergences between the different courts and decided to control again these legal characterization. And therefore, I would say, as a conclusion to this point, there is no clear general policy. It is indeed really a policy issue of the Court of Cassation. But this scrutiny, this review of the legal characterizations of the facts is very, very important, because it is on the facts of the dispute, of course, that the highest court examines whether the law has been correctly interpreted and applied. In addition to that, the French Court of Cassation has developed a list of cassation grounds. One could say opening grounds, that mean grounds, cas d'ouverture, which open the access to the court. There is no official list, and the Court of Cassation may decide what cassation grounds can be accepted. In fact, they are mostly the same for a very long time. They have been the same for a very long time. It is a very also formalistic requirement, since we have an article of the CPC which states how these these cassation grounds have to be mentioned in the statement of plea, and you have to mention for each plea of part of plea one cassation ground, the part of the decision challenged, why the decision shall be questioned, etc. And this is very formalistic, and the Court of Cassation scrutinizes really the compliance with these formalistic requirements. I've just put here on this slide the cassation grounds we have now. There is no official list, as I said, and depending on the authors, you can find different lists, but the most important ones are there. As you can see, all cassation grounds amount to a violation of the law in the broad sense, of course. The most interesting one is, in my view, the lack of legal basis. You know, the one of the last I mentioned, because it is really interesting to see that it is a lack of reasoning, a lack of reason. There are some reasons, but not enough to enable the Court of Cassation to exercise its scrutiny. For example, the lower court apply contractual liability against a party, but does not specify which contractual obligation has not been complied with. There are elements of facts, reasons missing, and the Court of Cassation cannot exercise its scrutiny. In such a case, of course, the Court of Cassation will say, I cannot exercise my review. Facts are missing, reasons of fact are missing. Sometimes also the Court of Cassation will use this very interesting cassation ground in order to at least partially review some legal characterizations it doesn't want to review in full, or use it also to specify the legal requirements it wants to require to the application of a specific statute. And sometimes have noticed that before reversing case law, it sometimes uses this case of a cassation ground manque de base légale in order to say, I do not crash at once upon a violation of the law, but next time I will do that. I first start and make a first attempt. That was the case when there was a reversal of case law relating to the duty of the judge to apply sua sponte the French rules, conflict of jurisdiction rules. So that was the first things I wanted to say. I come back to a new tool. I come to a new tool, which was established in 1991, which was not an original feature of the cassation in France. It is called the request for advisory opinion. And what is that? It is, the goal is, in fact, to enable the Court of Cassation to give immediately, and not only in a distant future, what is the interpretation to make of a specific legal provision. And most of the time, it is used by the lower courts when a new Reform Act has come in force. And as you see, the Code of Judicial Organization requires three requirements to be met. First, it must be a new issue of law, presenting a serious difficulty, and arising in numerous disputes. Then any court of first or second instance can, by a decision, request the opinion of the Court of Cassation after communicating this information to the parties. It also applies for collective labor agreements. So it's an interesting tool for the court to very soon settle case law, I would say, not depending on a precise case, a concrete case, but of course the lower court must request this advisory opinion when there is a pending case before it. At the beginning, the advisory opinions were given by a specific panel. There was the president of the court, the president of chambers, etc. So it was not the specialist chamber on the issue to be dealt with. And this was, of course, problematic because sometimes the advisory opinion said, let's say, black, and then the specific chamber in a ruling said, right, no, it's not the right solution. And therefore, there was a change in 2016. And now the chamber, which is the specialist of a specific matter, let's say civil procedure, then second chamber, then has to give this advisory opinion. But what is very important is that this opinion is not binding upon the lower court, which requested it. It's very interesting because it is more or less similar with the protocol numero 16 to the European Convention on Human Rights, where a high court of a contracting state may ask for such an opinion, but without being bound by it. So it's very different from the preliminary ruling before to the European Court of Justice. There are some reforms which are contemplated with regard to this advisory opinion. The first reform could be to relax the requirements. For example, it would not be requested anymore that there must be a serious question arising, an issue arising in numerous disputes, but likely to arise or likely to have this or that consequence. The idea is to make the use of this tool easier for the lower courts in order to facilitate the access to the Court of Cassation as soon as possible on an abstract issue of law. This is really not linked at all for the Court of Cassation to an appeal in cassation. I've put here some statistical data, and as you can see, there are not so many. Between 2010 and 2019, only 131 requests, most of them in civil matters, but in fact, most of the requests come from first instance courts, and there are much more numerous in the last years, because of course of the growing complexity of law. And I think it is a tool which has really future and which will be used more and more, I think, by the lower courts. Another evolution I have to mention in this presentation is the new review in concreto of the conformity of French of the application of a French provision with the Convention on Human Rights. We have first a very important ruling given again by the Plenary Assembly, ruling that the contracting states to the Convention must comply with the decision of the European Court of Human Rights without waiting to be challenged before it, or without waiting to have amended their legislation. And I would say about 10 years ago, the Court of Cassation changed its methodology and started to review whether the application of a French legal provision, which is in abstracto compatible with the Convention, is also in concreto compatible with it in the precise case at stake, giving rise to an appeal in cassation. This is, of course, a very specific methodology because it is about to assess whether the application of a domestic provision leads or not to a disproportionate infringement of a fundamental right. This is called contrôle de conventionnalité in concreto, or contrôle de proportionalité, and it started, the most famous ruling is of December 2013, where a woman who married 20 years ago, the marriage was prohibited by an article of the Civil Code, and the Court of Appeal declared the marriage null and void, and the Court of Cassation said this is an unjustified interference with the exercise of the spousal right to respect for her private life, since the marriage was celebrated without any opposition and had lasted for more than 20 years. You can imagine what it means, because some scholars at once said it is horrible, of course. It means that the statutes are totally disregarded. The general and abstract norm of law disappears in favor of a kind of fluctuating approach. And of course, it is unpredictable equity. And some colleagues said also this is, of course, a factual analysis which the Court of Cassation provides, and this is not its task. Instead of remaining a judge only of the law, it becomes a legislator or a factual judge, and this is not possible. One must admit that there are, of course, dangers regarding this approach. The main dangers are first, a possible breach of equality, of course, between litigants, because in one case, the differentiated application of the legal norm will lead to a non-application, or by contrast to an application. And of course, this leads also to uncertainty and unpredictability. The issue is, of course, that this new review impact the distinction between law and facts before the Court of Cassation. Some colleagues indeed argue that this will be a first step toward the vanishing of this distinction. I personally think it is not the case, because as you know, the cassation technique in France is flexible, adaptable. We have these cassation grounds. We have a great freedom in the Court of Cassation's hand. And this cassation technique does not fully exclude the facts from the court's reasoning, but the Court of Cassation cannot assess these facts, which is very different. And I think that this evolution simply reflects that there is a broadening, let's say, or a different nature of the review related to the legal characterization of the facts that we already mentioned. A new tendency too is the broadening of the possibility of quashing a decision without remitting the case to a lower court. At the beginning, of course, the Court of Cassation could only quash and remit to the lower court. There was no other issue, or of course dismiss the appeal in cassation. And you remember this provision, the Court of Cassation does not deal with the merits of the case. From 1967 for the Plenary Assembly, and then, if I remember correctly, from 1979, there were some exceptions. In the previous version of this provision, L411.1 of the Code of Judicial Organization, there are two cases in which the Court of Cassation could quash without remitting to the lower court. It was, first situation, very clear. The quashing does not imply a new ruling. For example, there is no jurisdiction of French courts. Then you do not need any ruling. The second situation was when the facts as established and assessed by the judges of the lower court allowed the Court of Cassation to apply the appropriate rule of law, simply by applying the right provision, the proper provision to the facts as assessed. Now, since 2016, there is this very important change in civil matters. The first situation remains. The Court Cassation may also rule on the merits when this is justified by the interests of the sound or proper administration of justice, which is very, very vague, of course. And this is taken from the State Council, the highest administrative court in France. What does this mean, proper administration of justice? It could be a door, a gate open to many excesses, which is not the case. It is still only a mere possibility for the Court of Cassation, by contrast to German law, where the requirements are met, the Bundesgerichtshof must decide the case on the merits. And I think it's better because in France, this mere possibility can lead, of course, to a break of equality, the breach of equality between the litigants. The goal, of course, is to take into account the time of the procedure, the parties' interest to obtain as soon as possible a decision putting an end to the litigation. It is also, of course, procedural economy because there is a very, very heavy overload of the appellate courts in France, and therefore, when the Court of Cassation can quash without remitting the case, it can be useful. Does it lead to the vanishing of the traditional distinction between facts and law? I don't think so, in fact. Of course, the wording is very, very broad now, but according to some scholars who have checked this, the Court of Cassation makes the same use of this possibility as before, under the previous wording of the provision. And in fact, this ability to rule on the merits is not an infringement of the distinction between fact and law, I think, but of course, it strengthened the conception of the Court of Cassation as a third instance court, of course, with limited power. One can notice, nevertheless, that in that way, the Court of Cassation is moving away from the traditional cassation models. If you look at this statistical data, you see there are not so many cassations sans renvoi, without remittal, 320 in 2020, but I think there are more and more partial quashing without remittal or total quashing without remittal. It depends. And in the youngest, most recent decisions, there is more and more use of this tool. As a conclusion, I would like to ask whether there is a transformation of the cassation model in France. As you can see, and Lucie will present this in different aspects, there are numerous changes. There have been numerous changes for a few years, innovations. And my impression or my opinion is that the French Court of Cassation wants to play a major role and to participate in meeting the challenges of the justice of today. What are these challenges? Of course, the growing complexity of the interaction between legal law from different origins, also the dialogues between French courts, domestic courts, and European courts. Of course, more and more, the defense of the fundamental rights and freedoms, with especially this new convention review in concreto, more generally, defense of the rule of law, which is sometimes endangered in our European Union, as you know. Also, to take into account the necessary procedural economy and this right to a judicial decision within a reasonable time. And this is our quashing without remittal to the lower court, which would take 2 more years, and this is not necessary in some case. So I would say the Court of Cassation also strives to strengthen its legitimacy, by communicating better, by being more transparent, as well as drafting its rule in really a more clear and more modern way. And nevertheless, the distinction between facts and law remains, I think, at the heart of the cassation technique, and it will remain. And also these new tools that we have mentioned, or these processes that have been introduced in order to help master the new challenges, will not, I think, infringe this distinction. What we can say is that this cassation technique, as I already said, is really subtle but flexible, and becomes flexible when it is necessary to meet some goals, or to meet some danger that occur. Thank you very much for your attention. I hope I was not too long.
Thank you so much, Professor Ferrand. May I ask a very short question, actually? Jura novit curia. To what extent does the Supreme Court actually control a lower judge for not observing, of not having observed jura novit curia without opening up the facts? Generally speaking, the Supreme Court actually contains itself to the facts as the assumption of facts contained in the judgments.
Yes. That means that the Court of Cassation never put into questions the facts as assessed, but if there are errors in the reasoning or lacking reasons, then it can of course quash. That does not mean that the judgment is wrong, but that there are reasons missing, or that the errors are made which require an annulment of the decision. But jura novit curia does not apply as largely in France and as generally as in Germany, for example. So that was I explained with regard to this decision given by the plenary assembly in December 2007. And then you see the Court of Cassation said, no, we do not put on the judge of first or second instance a too heavy burden to apply ex officio the proper legal rule if it is not raised by the parties. So, it's it's restricted, which is a pity, of course.
Thank you so much. And now I would like to give the floor to Madame la Professeure Lucie Meyer, Professeur à l'Université Paris 2, Panthéon-Assas. She will speak about the aim of cassation and the conditions of filing a cassation under French law, of course, decisions subject to cassation, parties and time period. Madame Meyer.
Thank you very much, Mr. Dean. First, I would like to thank my Greek colleagues, of course, the organizers of this conference, Kalliopi Makridou and Georgios Diamantopoulos, and also Jiannis Delikostopoulos, who first contacted me. I'm very pleased to be part of this discussion with you this evening. So I will share my screen too. There. Okay. I was asked, as you just said, to present the aim of cassation and the conditions of filing a cassation under French law. Well, the traditional aim of cassation in France appears in the definition of the Court of Cassation. Just a moment, because I can't. There. Sorry, I quote this definition of the Court of Cassation from the Vocabulaire Juridique Gérard Cornu, which is a reference book. And it says that the Court of Cassation is the highest court of the civil system, whose mission is to ensure compliance with the law by overturning, in final instance, decisions that breach it, and to safeguard the unity of interpretation of the law. The first element arising from such a definition is that the Court of Cassation is a court. As Article L411-2 of the Code of Judicial Organization provides, the court rules at final instance on appeals in cassation made against decisions and judgments rendered as a last resort by the civil courts. And Article 604 of the Code of Civil Procedure, which Frederique already quoted, defines the appeal in cassation. It's the translation is slightly different, but it's not really different. The appeal in cassation, it says, tends to ask the Court of Cassation to quash non-conformity of the decision to the rules of law. Therefore, the role of the Court of Cassation is a jurisdictional role. It applies the applicable legal rule to the facts in issue, facts that have been established sovereignly by the judges at first or second instance. And then it decides if the appeal should be rejected or if the decision in issue should be quashed. I will start by describing the two principal types of missions of the Court of Cassation. On the one hand, ensuring the respect of rule of law, and on the other, through interpretation, ensuring the unity and the modernization of the law. And this will be the first part of my speech. Then I will describe how the Court of Cassation can be seized today in substantive law. That is, what are the conditions of filing a cassation today? And we will see that access to the court is wide open, which is due to the traditional conception of the respective importance of the two principal missions of the court. The mission to ensure the respect of legality and the mission to ensure the unity and evolution of the law are considered equal. None of them is more important than the other. This will lead me finally to talk to you about the doctrinal trend that tends to question the harmonious way in which these two missions coexist. A number of authors, mainly judges, and judges at the Court of Cassation, want to reinforce the missions related to interpretation at the expense of the first historical mission, the control of legality, which would be reduced to almost nothing. This is today an impassioned debate in France, a theoretical one, as it is closely related to the role of the Court of Cassation, but it has practical implications. First of all, the determination of the conditions of filing a cassation. I will start by describing the missions of the Court of Cassation. The first aim of cassation is the review of legality. The court ensures the respect of rule of law by quashing the decisions in breach with the law. This mission is, of course, in the interests of the individual parties to the dispute. It allows them to obtain a new decision on their case before the Second Court of Appeal, a new discussion before the Second Court of Appeal, a decision this time in compliance with the law. But I find it important to emphasize that this mission has also an objective of general interest. Indeed, it forces the judges at first or second instance to apply the law correctly because they don't want their decision to be quashed. In that sense, the mission of reviewing legality contributes to ensuring compliance with the law for all litigants. This is what the Italians call the nomophylactic function. We don't call it that way, but I'm sure you know the word because it's a Greek word, nomophylactic. Anyway, this function also serves the principle of equality. It guarantees to all the right to a decision that complies with the law. At least it does when access to the Court of Cassation is wide open. At the beginning, it was the only mission of the Tribunal de Cassation, which was the ancestor of the Court of Cassation, as Frederique said, as the Tribunal de Cassation had no power to interpret that rule, nor had the ordinary judge. Soon enough, though, the power of the judge to interpret the law was restored. In 1804, in the new civil code, the Code Napoleon, there was, and there still is, an Article 4, thus formulated: a judge who refuses to give judgment on the pretext of legislation being silent, obscure, or insufficient may be prosecuted for being guilty of a denial of justice. From this moment, the Tribunal de Cassation, renamed Cour de Cassation, had to undertake another mission. Indeed, it had to prevent each tribunal in France from having its own interpretation. Thus, the Court of Cassation had, from then on, the mission of unifying the interpretation of the law. This is why there is only one Court of Cassation in all the Republic, as the Code of Judicial Organization says. Initially, the court was meant to intervene only ex post, to resolve the differing interpretations by the lower courts. But soon, the Court of Cassation did not wait for such divergences to arise. It decided to indicate of its own accord the legal path to follow in order for the application of legal norms to be secure and foreseeable. The Court of Cassation could have stopped there with this mission of unifying case law. As a matter of fact, it is the only mission related to interpretation that is mentioned by the vocabulaire Gérard Cornu. It says the mission of the highest court is to safeguard the unity of interpretation of the law, and that is all. But the truth is, the mission of unifying interpretation of the law led the court to perform another mission. In effect, to unify case law, the Court of Cassation has to set out the exact interpretation of the law, the only interpretation. That means the court itself has to interpret the law. In doing so, it is led either to clarify the text simply, or to complete it, and sometimes even to contradict it, when it appears to the courts that the rule of law is not anymore in line with society's aspirations. Consequently, interpretation leads the court to modernize the law where it is necessary, which is another of its mission. And sometimes it does it in a very audacious way. I will take a famous example, the decision which is called Théphène, dated 16 June 1896. A steam tugboat had exploded, killing the engineer. The widow asks for compensation. At the time being, she cannot get anything, since the owner of the tugboat has committed no fault. The explosion is due to a manufacturing defect. There are some special liability regimes in the civil code at that time, but none of them concern this situation. It only concerns liability for harm caused by animals or by ruined buildings. Nevertheless, the civil chamber of the Court of Cassation feels it cannot leave the victim without compensation. How does it proceed? It decides to apply to the case Article 1384 of the Civil Code, and more specifically, paragraph 1 of this article. This is strange because paragraph 1 is not meant to set out any rule. It is purely an announcement of the rules that follow. It says one is responsible not only for the damage caused by one's own acts, this is a reference to Article 1382, but also for that which is caused by the acts of persons for whom we are responsible. This is a reference to the other paragraphs of Article 1384. Or by things that are in our custody. And this is a reference to the two following articles, the ones that regard animals and ruined buildings. So this phrase was absolutely not intended to have its own autonomous normative value. Well, the civil chamber decides that this text means, in an absolute sense, one is responsible for the damage caused by things that are in our custody, meaning anything that is in our custody, not only animals and buildings. This initial gesture then led the Court of Cassation to build decision after decision over decades, the entire regime of a general liability for the actions of things. Such a spectacular interpretation of a legal text does not happen very often. Yet, as we will see, some people regret that this is not more frequent. Before coming to that point, I would like to indicate that the missions related to interpretation, that is unifying and evolving the law over time, exclusively serve the public interest, contrary to its mission to review legality, which serves both private and public interests. And this leads me to mention a particular appeal, the appeal in the interest of the law. This appeal is very specific, for it does not aim at all to review legality, but only to direct the interpretation of the law. In fact, it's performed quite independently of the parties. Such an appeal is available exclusively to the Attorney General. The aim is to obtain censure by the Court of Cassation of an interpretation contained in a decision that may no longer be appealed. The remarkable point is that this censure has a purely doctrinal scope and does not affect the rights of the parties. Its aim is exclusively to prevent the development of illegal case law. Appeals in the interest of the law are rare. Among the most famous decisions, I will mention the Alma Mater decision of the Plenary Assembly of 31 May 1991. Thanks to this appeal, the court affirmed the principle of prohibition of surrogacy agreements as contrary to principles of the inviolability of the human body and the unavailability of civil status. There you see the request from the Attorney General mentioning that the decision can no longer be attacked. The Attorney General emphasizes that the question is most sensitive because it regards a social and ethical problem. And there and here is the decision. It says that it is handed down, it is handed down in the sole interest of the law, and that the case will not be referred back to the judges of first instance. That means that the quash decision must be enforced between the parties. You will find more details about this particular appeal in my written contribution. So we have just seen that the Court of Cassation performs two types of missions. The question is, what's the relation between them? Is one more important than the other? Can one exist without the other? As I shall now explain, both missions are considered equally important, which explains why the conditions of filing a cassation are not very restrictive in substantive law. If one considers that the respect of legality is an objective that is no less important as the unification and modernization of the law, access to the Court of Cassation must be conceived widely. Every party complaining of a non-conformity of a decision should be allowed to try to obtain its destruction. Inversely, if one considers that the primary mission of the Court of Cassation is to unify and evolve the law, and that this mission would better succeed with a reduction in the number of appeals to the court, then the tendency would be to limit appeals in cassation to cases that are likely to give the court occasion to carry out this mission. In substantive law, it's the first conception that's implemented. Traditionally, it is even admitted that the primary function of the judge of cassation is to ensure the proper application of the law by the courts. The judge of cassation is first and foremost the judge of legality, hence a large access to the courts. Of course, in one sense, access to the court is restricted in that one can only seize the court when one has purely legal grounds on which to contest the decision. However, access to the Court of Cassation is also generally wide in the sense that the conditions for admissibility are no more restrictive than the usual conditions for admissibility of an appeal. Sorry. These conditions are as follows: compliance with time limits, generally 2 months from service of the decision, the existence of an interest, the decision under appeal must be unfavorable to the appellant, the existence of standing, the appellant should have the quality of party or should have been a third party subject of an order in the decision under appeal, and the nature of the decision under appeal. It should be a decision handed down at last instance. It should be noted that the proceedings before the Court of Cassation are written proceedings, in which representation by a lawyer to the Conseil d'État et à la Cour de Cassation, to the Council of State and the Court of Cassation, is compulsory, except for a few very rare exceptions. That means that the appellant must be represented by a lawyer from a specialized bar. This could appear to limit the openness of access to the Court of Cassation, but in fact, it's not a real obstacle to the submission of an appeal. Firstly, in a sense, access to the court is rather improved by the obligation to use the services of a special counsel, since it will allow the appellants to present their grounds for cassation in a correctly structured and reasoned way. He is more likely to be convincing. It is true, though, that frequently, in approximately 30% of cases, lawyers advise against the party making an appeal. However, they do not raise obstacles to access to the court. It is the appellant, advised by the analysis of the special counsel, who is free to decide not to run the risk of having an appeal rejected. Secondly, there is legal aid that allows total or partial financing by the state. The intervention of a specialized bar does thus not have the effect of restricting access to the Court of Cassation. Finally, you can see that there exists no procedure for the selection of final appeals, no filter. True, there is a special procedure since 2003 called the procedure of not specially reasoned rejection, but it is not a filter. It works that way. After written submissions are filed, a restricted bench from the chamber may decide that there is no need to rule in a specially reasoned decision where the appeal is inadmissible or where it is manifestly unlikely to result in cassation. In other words, in this last case, the court may simply reject the appeal with the phrase, since the grounds for cassation invoked against the decision are manifestly unlikely to result in cassation, there is therefore no reason to rule through a specially reasoned decision. That means no reason at all are given for the rejection. Such a procedure does raise questions as to the observance of the right to a defense, but it does not amount to a selection since the appeal is examined by the court and sometimes very carefully. Only the decision of rejection does not give the reasons for it, which saves time for the Court of Cassation and helps it to hand down all its decisions in a reasonable time. In fact, until 2018, the Court of Cassation handed down around, in civil matters, around 20,000 decisions a year. In 2019, this number fell down to 17,500. Nowadays, however, this procedure of rejection without giving any reason for it is not considered sufficient by some authors. Many of them are judges. It is now time to present the impassioned debate that has been dividing the legal doctrine for the past years. The idea has emerged, first, that the mission of unifying and modernizing the law is more important than the mission of reviewing legality. And second, that the important number of appeals on which the Court of Cassation has to rule today prevents it to fulfill this more important mission in good conditions. Actually, this idea dates back to 1978. In a famous article, André Tinck, a very well-known and esteemed French professor of law, had asserted that the raison d'être of a Supreme Court, its essential function, can only be to clarify the law and modernize it. The Supreme Court rules in the interest of the law, therefore of all citizens, more than in that of the litigants. According to him, the mission of reviewing legality is thus a secondary mission. No wonder André Tinck finds it difficult to accept that only 1.5% of final appeals lead the court to setting out a new or important rule. All the rest of appeals fall under the mission of reviewing legality. This is not acceptable to him. He says, the hasty examination of thousands of cases is not compatible for a Supreme Court with the performance of its essential mission. And he asks, how can we accept that the most senior judges of the nation are largely in service to parties that are dissatisfied, and sometimes in bad faith? You notice that he admits the parties are not always in bad faith. Some do have legitimate reasons to file a cassation, but even regarding these parties, André Tinck finds it shocking that the senior judges should be at their service. Incidentally, I can't help but wonder why the fact that a judge may quash a legally incorrect decision in favor of a party acting in good faith is such a dishonor in his eyes. But anyway, the idea was taken up nearly 40 years after by Bertrand Louvel, first president of the Court of Cassation at the time. In 2014, he set up a review commission in charge of reflecting upon the necessary evolution of the highest court. Some members of the commission pleaded for the establishment of a filter of appeals in order to allow the Court of Cassation to be refocused on its normative mission, that is, the missions related to interpretation. What seems to really guide the supporters of this reform is the wish that the Court of Cassation would hand down very few decisions, all about important legal points, so that these important decisions would not be lost in the crowd as they are today. That way, the Court of Cassation would at last appear as a true superior court, ruling exclusively where it is necessary to show the way, as do the Conseil Constitutionnel, the Constitutional Council, the Council of State, the Conseil d'État, the European Court of Human Rights, and the Court of Justice of the European Union. You can detect here a strong desire for the court to be more visible, even to exist among the different Supreme Courts in France and in Europe. This is why in 2018, Bertrand Louvel asked a committee to prepare a draft amendment to the Code of Judicial Organization that introduced a filter system. The criteria for selection proposed were the following. The Court of Cassation shall only allow appeals where, first, the case raises a question of principle of interest to the development of the law. Second, the case raises a question of interest to the unification of case law. And third, if there is a serious breach of a fundamental right. Such a proposal led to an impassioned debate. Frederique Ferrand took an important part in this debate, showing that the German model, which principally inspired the authors of the text, was not so inviolable and was the subject of much criticism in Germany. It was also pointed out that selection would create inequality between, on the one hand, the great majority of claimants that might have to suffer the consequences of a decision that did not comply with the law, but where an appeal would not raise a sufficiently interesting legal question, and on the other hand, the tiny minority of those who would be able to have the decision quashed. Besides, it was argued that selection would harm the constitutional principle of separation of powers, in that it would lead the Court of Cassation to decide to rule on a question of principle. Just as the legislator, I have to go a little bit quicker now. And finally, I am almost finished. Finally, it has been highlighted that maybe it would be time to discuss a reduction of appeals in cassation when the quality of decisions at first and second instance would have improved. The reality today is that up to a third of appeals actually examined by the Court of Cassation lead to cassation of the decision. How can we consider letting so many litigants compelled to enforce an incorrect decision? To calm the debate, the Justice Minister at the time, Nicole Belloubet, entrusted to a working group the mission of reflecting on the issue, the group Henri Nallet. The group concluded that it would be impossible to implement a selection system. It favored other ways, and especially it favored the implementation of differentiated paths to appeal. This last proposal had in fact been examined and finally rejected by the review commission named by Bertrand Louvel. It consists in leaving access to the Court of Cassation open, but have a simplified handling of cases that can only lead to a purely disciplinary cassation. In the meantime, the first presidency changed from Bertrand Louvel to Chantal Arens, who is against selection, and as is François Molins, who had become first advocate general. These two personalities decided to implement the idea of differentiated paths to appeal, and it is at the present time being gradually introduced in the appeal in cassations procedure. But the first presidency of Chantal Arens will soon come to an end in the very next month, I think. Who will it be next? Will the selection system, the filter system, rise from its not so-called ashes? The future will tell. I thank you for your attention.
Thank you so much, Professor Meyer, for this enlightening lecture. I would have questions, but let's proceed to the next speaker, who is my colleague, Mr. Dimitrios Tsikrikas, professor at the Faculty of Law of Athens, who will speak about the aim of cassation and the conditions of filing cassation under Greek law. Of course, decisions subject to cassation, parties and time period. Good evening.
Thank you. Thank you very much, Mr. Chairman. First of all, I would like to thank very much Professor Makridou and Professor Diamandopoulos for the kind invitation to participate at this very important conference. Thank you so much, dear colleagues. First of all, I have any remarks over the Greek model of the cassation in the European comparison. Any short historical remarks. The contemporary review appeal of cassation in the continental procedural law is, in my opinion, based on the appeal of supplicatio ad Caesarem Majestatis of the post-classic Roman law, and especially of the time period of dominat. This appeal has impact on the appeal of the French appeal of supplication au roi of the French medieval law, which was submitted to the Conseil du Roi, Curia Regis. Further, the appeal of the French law, which is renamed cassation, had them to protect the law, and especially les ordonnances du roi, and secure the priority of the legislative action, called primauté législative. The Conseil du Roi is abolished by the French Revolution, but a new court, le Tribunal de Cassation, is provided as in my opinion, as organ of the legislative function, of the legislative power, the French verdict établi auprès du corps législatif. And then, due to the power of the French courts to interpret the law, this power is provided by the French Civil Code, was necessary to secure the unification of the court decisions and as well as the correct interpretation and application of legal norms by the courts. This function was fulfilled by the cassation as a review appeal submitted to the Cour de Cassation, which was yet a judicative organ. this is any remarks over the historical evolution of the review appeal of cassation. Yet the Greek law, the Greek contemporary law, was in the time period during and after the War of Greek national independence under the influence of the French law. Therefore, a Supreme Court in the model of the French Tribunal de Cassation was provided. Further, in the first time period of the King of Greece, Otto from Bayern, the professor of law, Georg Ludwig von Maura, in his capacity as a member of the Regency Council of the young king, elaborated among 4 codes the Civil Procedure Code, das Gesetzbuch über das Zivilverfahren. According to the legal orientation of the Georg Ludwig von Maurer, who was professor for French law in Munich, the Civil Procedure Code was influenced by the common German procedure, the Gemeinen Prozess, the Bavarian procedural drafts, and mainly, my opinion, by the French law and especially by the Code de Procédure Civile. The cassation in the Civil Procedure Code was oriented towards the model of the French pourvoi en cassation, and according to its function, cassation was a review appeal intended to secure the correct interpretation and application of the legal rules and the uniformity of the court decisions. Nomophylakia, according to the wording of Piero Calamandrei, Italian wording, Piero Calamandrei, in his famous work, La Cassazione Civile, a famous comparative work, Professor Mayer. This aim, nomophylakia, was relevant to the formulation of the grounds of cassation. First of all, violation of substantive law rules, either by false interpretation, false interpretation, or by erroneous application, false application, as in the French law, and further, lacking of legal base of the judicial decision, manque de base légale, or défaut de motif, are 2 of the most significant grounds for cassation introduced in Greek civil procedural law under the influence of the French law. Further, the influence of the French law was evident and by the provision of a ground for cassation based on the rules governing procedural nullities, la nullité. The French influence was evident as well as in the possibility of the public prosecutor of Areospagos Cassation Court. Areospagos was and is the Cassation Court to file a cassation in the interest of the law against any judicial decision, even non-contestable through a cassation by the parties. This cassation in the interest of the law was similar to the French institution of the Cassation dans l'intérêt de la loi, submitted by the Procureur Général près de la Cour de Cassation, which had the aim to secure the correct interpretation and application of the rules of substantive law. And yet, any remarks to the aim of cassation in the contemporary Greek procedural law? The new Civil Procedure Code is based on the models of the German, Austrian Code of Civil Procedure Law, and further on the French Code de Procédure Civile as well. The cassation is provided in the Civil Procedure Code as extraordinary judicial remedy, voie de recours extraordinaire, and specially as a review appeal based on the distinction between law and fact. According to a strong opinion in the legal doctrine, the cassation intends principally to secure the correct interpretation and application of the legal rules and the uniformity of the court decisions. This is the main opinion in the legal doctrine. However, in my opinion, the importance of the cassation for the effective judicial protection of the legal interest of the parties cannot be denied. And therefore, an important part of the legal doctrine admits yet, as aim of the cassation, the effective judicial protection of the legal interest of the parties as well. The aim of cassation to secure the correct interpretation and application of legal norms and to contribute to the uniformity of court decisions and the modernization of the law as well can be explained through any regulation of the Civil Procedure Code concerning the grounds for cassation and its proceeding. First of all, the grounds for cassation are limited to issues of law, either the false and erroneous interpretation and application of substantive law rules or the violation of procedural rules and principles. Issues of fact are excluded from the control of Areospagos, the Cassation Court. Contrary to appeal, the judicial remedy of appeal, contrary to the judicial remedy of appeal, which can attack a judicial decision on any grounds, on any issues related to law and to fact, and which allows a rejudgment on the merits, by the Court of Appeal. Cassation allows only the legal control of the judicial decisions and not the case on the merits. As in French procedural law, la Cour de Cassation juge les arrêts et non les procès. The legal control of judicial decision is oriented towards the aim of cassation to protect substantive and procedural law and contribute to the uniformity of court decisions over the interpretation of legal norms. Norms of constitutional origin, of European law origin, and especially norms of European procedural law. The protection of the, in French wording, acquis communautaire is very important, in my opinion, for the function of the cassation in the Greek law as well. Cassation is normally entertained by a civil panel, sabre civil of Areospagos. However, a cassation can be introduced before the plenary session, Assemblée plénière, of Areospagos, either by a common decision of the president of the court and the public prosecutor of Areospagos, or by a decision of the adjudicating panel for one or more grounds for cassation when questions of general interest arise, or when a decision of plenary session is necessary for the uniformity of the interpretation of a legal norm within the decisions of the lower civil courts. The adjudicating panel is obliged to transfer a ground for cassation to the plenary session, Assemblée plénière of Areospagos, when its decision is rendered with a majority vote of one judge, a majority vote of one judge, or when the panel refuse the application of a legal norm on the ground of its unconstitutionality. A plenary session of Areospagos has competence over legal issues of a great importance for the legal order, for the Greek legal order, constitutionality of legal norms, and the uniformity of the decisions of other lower civil courts. In order to avoid overloading of Areospagos and to secure the function, its function intended to protect legal norms, the Civil Procedure Code provides a pre-trial examination of the cassation and the ground of the cassation by a judicial council consisting of the president of Areospagos and two of its justices, a pre-trial examination by this council. the council decides after a proposal of the reporting judge and can order that the hearing of the cassation is cancelled when cassation is evaluated as inadmissible or manifestly unfounded. This provision is similar to the provision of paragraph 552A of the German civil procedure, Zivilprozessordnung, which allows to the competent panel, Senate of the Supreme Court, Bundesgerichtshof, to dismiss revision through an order, Beschluss, according to the German procedural law, when data is evaluated as manifestly unfounded. The influence of the German law on these issues. Further, according to Article 562, paragraph 4 of Civil Procedure Code, any grounds for cassation can be taken into consideration after a proposal by the reporting judge on own motion, ex officio, by the competent panel of Arios Pagos. This possibility allows to the Court of Arios Pagos to secure the correct interpretation and application of legal norms and to unify the court decisions. Under the influence of the French model, the Civil Procedure Code grants to the public prosecutor of Arios Pagos the possibility to file a cassation in the interest of the law, dans l'intérêt de la loi, also in order to secure the unified interpretation of legal norms and to avoid perpetuation of erroneous precedents. This possibility of the public prosecutor of Arios Pagos exists against any decision of civil courts, even non-contestable through a cassation filed by the parties without time limitations and for any cassation ground. Cassation in the interest of the law is introduced before the plenary session, Assemblée plénière of the Arios Pagos, and has in general non-binding effect for the parties. Further, any remarks to the function of cassation for the effective judicial protection of legal interest and legal rights of the parties? On the other hand, according to the main principle of civil procedural law of free disposition of the parties have the dominant position in civil litigation and in the law of judicial remedies, and especially in the law of cassation as well. Therefore, cassation can be lodged by a person or against a person who was a party in the civil process in which the attack decision was issued. Furthermore, the party filing a cassation must have a legal interest and substantiate that the prejudice from the attack decision will be avoided by the success of cassation. Also, the review appeal must be important for the effective judicial protection of the legal interest of the party filing the cassation. In addition to that, accessory intervention in the cassation proceeding is permissible for any third party who claims a legal interest in the victory of either one of the parties. Legal interest is condition for the admissibility of the accessory intervention, and it is connected to the impact of the cassation, the legalized and interest of the intervenient. Furthermore, a cassation, according to the Greek procedural law, can be based on the false and erroneous interpretation and application not only of domestic substantive law, but further of foreign substantive law. In the German wording, Revisibilität des ausländischen Rechts. In my opinion, it is obviously that this ground for cassation is important not for the protection of the Greek legal order, but for the effective judicial protection of the legal interests of the parties. The possibility to base a legal ground on the revisibility of the foreign law. According to the Greek Civil Procedure Code, it is possible for Aristotle, after annulation of the attack decision, to adjudicate on the merits of the case, even if this did not need further examination of facts, or to transfer the case to the court rendered the attack decision, or to another civil court equal in rank to that. However, after a second cassation, Aristotle is obliged to proceed to the merits of the case. This provision of Civil Procedure Code is, in my opinion, evident for the importance of the cassation for the effective judicial protection of the parties' legal interest. Cassation is a non-suspensing remedy, and the initiation of cassation cannot delay the enforceability of the attack decision. However, in any cases in which exists the danger of any irreparable harm to the opposing party produced by the enforcement of the attack decision, the competent panel of Aristotle has the possibility in a closed proceeding to order the suspension of the enforceability of the decision. It is, in my opinion, a further provision of Civil Procedure Code with importance for the effective judicial protection of the party opposing by cassation. The decision either of the competent panel of the plenary session of Aristotle over relevant legal issues has a binding effect only against the parties and not a binding effect erga omnes. Therefore, this binding effect is important for the effectivity of judicial protection in the concrete case. The uniformity within the decision of lower civil courts is based only on the general acceptance of decision of Aristotle, and especially the decisions of the plenary session. Therefore, a normative function of cassation in the Greek legal order cannot be admitted. Finally, according to the Civil Procedure Code, when the reversed decision is executed, Aristotle Cassation Court orders, after the request of the opposing party, a full restitution of the situation before the execution of the reversed decision, a full integrum restitutio. This is further a very important legal provision for the effectivity of the cassation for the rights and legal interest of the opposing party. The decisions which can be subject to a cassation can be final decision of civil courts when ordinary remedies, judicial remedies are not available. Therefore, cassation is the last review appeal against decisions of civil courts. A final decision of a court of appeal, as well as a final decision of first instance courts, can be subject to a cassation when ordinary remedies, appeal, or opposition against default are not available. A permission to review appeal granted by the court which rendered the attack decision, as in the model of the German civil procedural code, in the German wording, Zulassungsrevision, is not necessary according to the Greek procedural law. Non-final decisions cannot be subject to a judicial remedy, and especially of a cassation. The legitimation, to file a cassation in the interest of the law. Cassation is to be filed by a person who was a party or intervenient at the process at which attack decision was rendered, or a successor of this person. Those persons are legitimate to file a cassation against persons who are parties at the process or their successors as well. It is noted that in case of necessary joinder of parties, a judicial remedy, and especially a cassation filed by only one of the parties, affect all necessary joinder parties at the cassation proceeding, a general rule for the judicial remedies. As noted previously, the public prosecutor of Areopagus has the possibility to file a cassation in the interest of the law against any decision, even non-contestable, through the cassation filed by the parties. But in my opinion, this possibility of the public prosecutor of Areopagus is not in accordance with the modern function of cassation in the Greek procedural order as a judicial remedy intended not only to secure the correct interpretation and application of the legal norms to secure nomophylakia, but also the effective judicial protection of rights and legal interests of the parties. Also, to conclude, the cassation in the civil procedure code, in the Greek civil procedure order, legal order, is oriented principally towards the model of the French pourvoi en cassation, and according to its function, cassation is a review appeal, very important, really very important, for the interpretation and application of legal norms and the uniformity of court decisions. On the other hand, importance of the cassation for the effective judicial protection of the legal interest and legal rights of the parties in the concrete case, in my opinion, cannot be denied. Thank you very much for your attention.
Thank you so much, Professor Tsikrikas. It was really interesting, and I have noticed one specific point. Having in mind the attitude of the Court of Cassation of France, you mentioned actually the normative power of the Court of Cassation in Greece, which is very limited, if not inexistent, actually. Yes?
In my opinion, is very limited. Only the moral authority of the Areopagus, the Court of Cassation, can safeguard this possibility. The binding effect of the decisions of the Court of Cassation, Areopagus, either panel or assemblée plénière, is only binding on the parties. A binding effect, erga omnes, does not exist in the Greek procedural order.
Indeed. While the Court of Cassation in France, actually, as described by professors, yes, they have a broader power in modernizing what they call modernizing the law and interpreting the law. They may have, I have in mind, for example, they have created a moyen de cassation. They created for the revision of arbitral awards. This is my field, actually, in a case Proco-France contre Fougerolles, where the Court of Cassation has opened up a case for review, actually, while it was not written. It was not provided in the civil code, in the new civil code. It created the law. It just created the law, actually, which was amazing. And this is called the modernizing function. And now I would like to give the floor to my friend Jiannis Delikostopoulos. Thank you so much, Professor. Jiannis, you have the floor to enlighten us on, to shed the light on the distinction between facts and law on cassation and the evolution of the control exercised by the Court of Cassation under Greek law. Please.
And now you can hear me, Le Doyen? Yes. Okay, thank you. Thank you, Dean Glavinis. Thank you all. It is a privilege and a pleasure to be here among French colleagues and Greek colleagues and friends. The distinction between fact and law in Greek cassation proceedings, is it a myth or is it a real boundary? It is a real boundary, of course, as is the case in France, as explained by Professor Ferrand. But is it truly that important? It is important. But why is it that important? I believe it is important for two reasons. It satisfies a double telos. It runs both ways. It's not one-dimensional. On the one hand, it allows for a certain degree of control by the Greek Court of Cassation. And I would argue it allows for the right degree of control. On the other hand, it sets limits to said control. Now, the end result of all of this, and of course we could have a different conference on this issue, but I believe the end result of all this in the Greek legal system, in every continental law system, is the creation of a system of law, not mere precedents. And one can begin to understand this by comparing it with the European Convention of Human Rights System, the Strasbourg case law. Now, the Strasbourg case law is rich, it is important, it creates precedents, but it does not create, in my view, a system of law, as is the case in the French legal system, the Greek legal system, etc. And one of the reasons it does not create a system of law, as is the case in continental law systems, is because it does not know the distinction between fact and law. There is a blurring of the lines between the factual and the legal in the Strasbourg case law. Now, to start off with what is my thesis, which is, of course, the distinction between fact and law in Greek cassation proceedings, the essential provision here is Article 561, paragraph 1 of the Greek Code of Civil Procedure, according to which the substantive court's assessment of facts and of the content of documents in particular is not subject to cassation review, unless, of course, legal rules have been infringed, including interpretative rules or a ground of cassation as per Article 559, numbers 19 and 20 is established. Now, there are differing opinions on this, but 559 number 19, one could argue, is the mirror image, the direct equivalent, if you wish, of the French manque de base légale, whilst Article 559 number 20 refers to the deformation of the contents of a document. In truth, the rule is as old as is the making of the French Cour de Cassation, originally called, of course, Tribunal de Cassation. If one reads the decree, the décret of 1790, one would read, le tribunal ne pourra connaître du fond des affaires. Indeed, in Greek cassation proceedings, the Greek judges of cassation are not judges of fact. They're judges of law alone. They do not retry the case. They only control the judgment of the court of substance, usually the one of a court of appeal, for errors of law alone. In Greek proceedings, always, in the final judicial reasoning, the following are subject to cassation review for direct or indirect violation of the law, the legal qualification of facts, as in France, the subsection of facts to legal concepts, the lack of use, the lack of recourse to the significant general interpretative rules of Articles 173 and 200 of the Greek Civil Code, if and when an interpretation is needed. The specification of vague legal concepts, it is critical, I will come back to this point. The extreme limits of legal concepts that I would characterize, and there are differing opinions on this in Greece, as legal concepts of a dual hypostasis, hybrid legal concepts. There's both law and fact into them. An example, Article 932 of the Greek Civil Code. The Civil Code adjudicates a reasonable pecuniary compensation due to moral damage or due to pain and suffering, if a death is involved. I would argue this is both legal and factual. And finally, the evidential reasoning, the extreme limits, to be exact, of the evidential reasoning and of the discretion of the court of substance. And by this I mean that if there is an important piece of evidence in Greek civil proceedings that is a game changer, meaning if it had been taken into consideration, it would have led to a different judicial outcome. If it had been taken into account, it would have led to a different judicial conclusion. If it is not unequivocally certain that it has been taken into consideration, then a ground of cassation is established, peu importe le numéro, Article 559, number 11 of the Greek Code of Civil Procedure. To simplify all of this, whenever facts are subjected to legal concepts in Greece, whenever facts are subjected to legal concepts, there exists a possibility of Greek cassation review. But of course, one has to be dealing with legal concepts. And in Greece, as is the case sometimes in France, it's not always obvious whether we're dealing with a legal concept or not. Case at hand, the acceptance of a claim. Same discussion goes on in France, and Professor Makridou has written extensively on this subject in Greek proceedings. It is not a mere admission of facts. In my view, it's a legal concept. The rights of the defense, another legal concept. An issue which is close to the heart of Doyen Glavinis, ultra petita in arbitration proceedings. If there is contrary case law, one or two decisions by the Greek Court of Cassation, but in my view, if an arbitral tribunal adjudicates in excess of its authority, meaning beyond what was agreed in the arbitration agreement, then there is ample scope for cassation review. Now, allow me for a few examples. These are just examples, there are many more, of judgments about questions of fact that are therefore unreviewable in cassation. The fictitiousness of a sale. Of course, if there is a donation hidden behind it, there is room, there is ample scope for cassation review. The market value of a property. The maturity of a child in a child custody case. Can a 4-year-old be heard before the court? In my view, not, but that's not the issue. The issue is, it is a question of fact. Can a 5-year-old be heard before a Greek civil court? Maybe yes, maybe no, but still a question of fact. Evidentiary issues that arise in the course of the proceedings. Moral incapacity to obtain a document by a party, question of fact. Do we need to appoint an expert witness as per Article 368, paragraph 1 of the Greek Code of Civil Procedure, unreviewable in cassation? Do we need to hear oral testimony in what have become prima facie, in principle, written first instance proceedings in Greece? Again, unreviewable in cassation. Procedural issues that arise in the course of the proceedings, the adjournment of the case, the costs of a case, the concept of a crucial document in revision proceedings as per Article 544, number 7 of the Greek Code of Civil Procedure. Whether a new allegation can be made on appeal because, and only because, all the rest is legal, because and only because it can be proven on the spot, paraχρima. Whether it can be proven on the spot or not is factual, and many more. There are also cases where, for the same case at hand, there can be a double cassation on an issue of procedure and an issue of substance. One example, justifiable application to set aside a default judgment due to force majeure as per Article 501 of the Greek Code of Civil Procedure. Both are reviewed at all ends, but if there is an erroneous rejection of the application to set aside the default judgment, this is considered to be, rightly so in my opinion, a procedural issue. So it is reviewed under a procedural ground of cassation, 559 number 14. Whether there is force majeure or not, it is considered to be, again, rightly so in my view, an issue of substance. So it will also be reviewed, but as a question of substance and under a ground of cassation, which is considered substantive, Article 559 number 1. Now, for reasons of time, in order to follow the time instructions, allow me to move on. There's a lot more in my written presentation to the important issue of the specification of vague legal concepts. And then finally, of course, the most important chapter, the development, the evolution of the control, as I see it at least, by the Greek Court of Cassation. Now, vague legal concepts, what are we talking about? We're talking about legal concepts, the definition of which does not immediately derive from the provisions of the law. They're usually regulatory, they may well be descriptive. Examples of legal concepts in Greek proceedings, the same discussion in France. Public order, good faith, force majeure, causation, negligence. the best interest of a child in a child custody case, the significant effect on the visitation right of one parent if the other parent relocates together with the children. An example. So you have a mother who takes the children and moves back to Lyon. And then the Greek court retains jurisdiction as per Regulation 2201 of 2003 for 3 months, and the same as of August 1, 2022, as per Regulation 2019-1111, again for 3 months. So the Greek court decides no substantial effect whatsoever on the visitation rights of the father. Well, such a decision would certainly be open, in my view, is certain to cassation review in Greece. And then there are concepts, and this becomes a little more interesting perhaps, which originally, I believe, they were not vague at all. They were very definite. And yet, through expansions, they have become, on occasion, vague. And the reason is, of course, why. I believe the common element here, the common thread, if you wish, is that the law ought to be. The law never is. The law ought to be, and therefore the law is. And Professor Mayer made some allusion at this point from a different perspective, from, of course, a French perspective. 2 examples. Domicile, family. Domicile, Article 51 of the Greek Civil Code. Corpus and animus, main and permanent settlement. There is nothing more definite than the concept of domicile in the Greek Civil Code. And there can only be one domicile legally in Greece. You cannot have 2, 3 domiciles. Of course, there can be many domiciles for the purposes of service of a document. If the defendant has a house in Thessaloniki and a summer house in Chalkidiki, I can serve the lawsuit at either Thessaloniki or in Chalkidiki. But other than that, for the purposes of establishing, for example, jurisdiction, in a Greek case, there can only be one domicile. Whether it is a purely Greek case or whether it is a European Greek case, Regulation 1215 of 2012 differs to national law on this point. Or whether it is a truly international non-European case involving US citizens, Australia, etc., there can only be one domicile in Greece. And yet, due to recent changes in Greek family substantive law, not procedure, not procedural law, family substantive law. Consider the following example, hypothetical. A Greek court may decide, or it may not, depending on the best interest of whether it considers to be the best interest of the children, that the children will stay 1 week with the mother, 1 week with the father. 15 days with the mother, 15 days with the father, a case of we call split habitual residence. In such a case, one can argue that children nowadays have a double domicile. Family, I think, is more clear. Now, originally, extremely definite. Now, not definite at all. One hypothetical. It is a pure hypothetical. There's a man, he's married, he's not divorced, not at all, but he lives with his mistress for the last 5 years. And he drives, not in Thessaloniki, but in the Attica region towards Cape Sunio, and he dies. So he suffers a horrible death. So the question then becomes, who has a right to sue to ask for a reasonable pecuniary compensation due to pain and suffering? Well, both the wife and the mistress have a right to sue. Does this mean that the concept of family has become vague? Yes, that's exactly what it means. It means that it has become vague through expansions. And the reason being, in my view, because the law ought to be. Now, I move on to the last chapter, which concerns the evolution, the development of the control by the Greek Court of Cassation. Allow me to say that I have written on quite a few trends in the written presentation. Here, in order to satisfy time requirements, I will stick to 2. One which is, I believe, positive, and one which, if proven to be correct, is less than positive. Now, the most important development, in my view, in this area of the law, in the control exercised by the Greek Court of Cassation, is the use by the Aristotle of general principles of law, such as the principle of proportionality, such as the presumption of innocence, ne bis in idem, which is done in such a way by the Aristotle that there is no legal uncertainty. And the reason being is, I believe, because the Aristotle exercises extreme judicial self-restraint. And by this, I mean very specifically that only the extreme limits of the discretion of the Court of Substance are reviewed here. Only the extreme limits of the discretion of the Court of Substance are reviewed here. Case at hand, plenary session decision, number 9 of 215, principle of proportionality. So the claimant, it was a company, asked for 3 million euros for moral damage as per Article 932 of the Greek Civil Code. They get 30,000 euros. They asked for 3 million, they got 30,000 euros. Is this a violation of the principle of proportionality? No, says the plenary session of the Arios Powers in its decision number 9 of 215. A first example, extreme judicial self-restraint. Only the extreme limits of the discretion of the Court of Appeal, usually of the Court of Appeal, will be reviewed. Another example, more recent, equally important, plenary session decision number 4 of 220. It concerns presumption of innocence and, of course, ne bis in idem. Before I get into this, allow me to say for 10 seconds for our French audience that in Greece, unlike France, but as is the case in the United States, there is no autorité de la chose jugée au pénal sur le civil. There is no res judicata stemming directly from criminal proceedings into civil proceedings. So what happens in Greece? In Greece, as is the case in France, you may well have a case which has a criminal aspect and a civil aspect. And the criminal proceedings may lead to a criminal acquittal or to a criminal conviction. Theoretically, both are important. In practice, in truth, the criminal acquittal is more important. So once you have the criminal acquittal, the civil court can differentiate itself. It can find differently from the criminal court, but it must do so under 2 conditions. First, it must use the criminal court's acquittal, if it is an acquittal, as a strong presumption. And it must justify itself for the different findings from the ones of the criminal court. So a strong presumption and explain yourself. If these 2 requirements are met, there is no cassation. If it is not, again, the phrase, listen to it. If it is not unequivocally certain that it has taken into consideration as a strong presumption the criminal court's acquittal, then ground of cassation as per Article 559, number 11 of the Greek Code of Civil Procedure. Again, in my opinion, an example of judicial self-restraint. Now, before I get into what, if proven correct, is a rather not positive, if not outright negative development in the exercise of control, exercise of the Greek Code of Cassation, allow me to say the following. I strongly believe that the overriding test, the litmus test, the most important test in what makes a Court of Cassation, a Supreme Court, successful is not so much what the Supreme Court can do, because let us face it, a Supreme Court, a Court of Cassation can do many things. It is more what it abstains from doing, even though it could do it. With this in mind, one can argue that on occasion, it is not the norm, on occasion, recently, Greek judges of cassation tend to be a little judges of fact. They tend to give stays of execution a little bit too easily. Now, why is that a problem? Well, first of all, it clearly subverts the role of the Greek Court of Cassation. The Greek judges of cassation are not there to retry the case. They're just there to control the judgment of the court of substance for errors of law alone. But is that enough, the dogma, the dogmatic point of view? Well, there's more to it. It creates a sense of foul play. It creates legal uncertainty, and it creates delays in the proceedings. One example, it may well be a hypothetical or not. A case originates in Greece in the first decade of the 21st century, specifically 2009. So you have court of first instance, it goes all the way up to appeal. Then there is a first pourvoi en cassation, first cassation, goes down to appeal level again. A stay of execution following a second cassation, a stay of execution is granted by way of example in 2021. Then the case will be heard by way of example in the last quarter of 2022. An irrevocable judgment will be rendered in 2023. And if, and only if, the second cassation is rejected, then what we call voie d'exécution, enforcement proceedings, may start at some point in 2024. So you have a case originating in 2009, and the claimant will know whether he can start enforcement proceedings or not 15 years later. Is this a one-off? It's not a trend, but it's getting there, and it's dangerous. I heard the numbers quoted by my dear friend and French colleague, 50% in France. We're not there yet, 50% of cassation, is that correct? But to the extent that any judge of cassation retries the case on the merits, then yes, it does produce delays, it does produce a sense of foul play, it does produce legal uncertainty, and it is against legal dogma. So thank you for listening to me. I hope I fully kept the time restraints. And again, and I mean it, it was a true privilege and a pleasure to be here among French colleagues and among Greek colleagues and friends. Thank you.
Thank you so much, Giannis, for this. Let me ask a small question, actually, a short question. the Court of Cassation is not supposed to look at the facts of the case. May he look at the way the case was decided before quashing a bad judgment, actually? My professor Philippe Fouchard in Paris used to say that don't be mistaken. The Court of Cassation will always look how the judgment has been, how the decision was decided, how the case was decided before quashing a bad decision. And who is more justice sensitive? Is the Court of Cassation in Greece, or is more formalistic than the Court of Cassation in France?
The last one was a tricky one, the doyen. Do you want me to compare who is more formalistic now, the French or the Greeks, before such a lovely French audience? Professor Fouchard was right, and we all have a lot of respect for Fouchard, and he was right, of course. They do. A good judge will always look at that, no matter whether he's a Court of Appeal judge or a Court of Cassation judge or a Supreme Court judge in the United States. More formalistic. Look, the human nature is the same in France as in Greece. We go through the same trends. We try and ameliorate our system and make it better. And then we make mistakes, and then we retry again. And then the next generation will come and say that we messed it up. I don't see any difference between French and Greeks. We're the same, from a dogmatic point of view. Thank you.
Thank you very much. And now I would like to give the floor to our commentators, actually, Assistant Professor Anna Plevri from the University of Nicosia in Cyprus. Thank you so much for being today here. Professor Plevri, so the floor is yours for a comment on what has been said until now.
Thank you. Thank you, dear Dean. I would like to thank the organizers, Professors Makridou and Professor Diamantopoulos, for including me in such a great conference. It is indeed a privilege and an honor. The topic of my short intervention is proceeding of cassation under Greek law. Cassation is the ultimum refugium for a party within the Greek legal order. It has been modeled on French law and brings the challenge judgment before Greece's highest court, the Supreme Court of Greece, Aristotle. The legendary name Aristotle comes from the ancient Greek judicial council, so called because it met on the hill Ares west of Acropolis in Athens. From an organizational point of view, the Supreme Court adjudicates cases either in panels, currently 6 handling civil cases, or in plenary session. All methods of review, cassation included, are initiated by filing a written petition with the clerk of the court which has rendered the challenge judgment, and not at the court to whom the remedy is addressed and is going to adjudicate it. In addition, all methods of review, cassation included, can be filed before the service of the judgment, and the effects start from the point they are filed and registered by the clerk of the court. Since 2012, the Greek legislator introduced a financial obligation regarding the admissibility of any method of review, including cassation. A party who files a cassation is obliged to pay a certain fee, together with a relevant written petition, which fee is attached to the report prepared by the clerk of the court. Since this financial obligation is a prerequisite for the admissibility of all methods of review, if a specific fee is not paid, the cassation shall be rejected by the Supreme Court as inadmissible without any further review of the case. The reporting judge is appointed in an early stage of the cassation proceeding, namely as soon as the date of the hearing is set. The sole task of the reporting judge is to evaluate whether the cassation filed is admissible or not, and whether the initial or additional grounds of the cassation are admissible or well-founded or not. In the latter case, the reporting judge proposes orally to the 3-member Judicial Council the dismissal of cassation. Supreme Court first checks the admissibility of the cassation in case the cassation has not been filed in accordance with the provisions of the procedural law, or if any prerequisite of admissibility is missing, the court rejects the cassation ex officio. When it comes to representation of parties before the Supreme Court, parties are obliged to be represented by a lawyer before any civil court in Greece. When it comes to the cassation proceeding itself, Article 96, Paragraph 3 of the Code explicitly provides that the power of attorney from the party to the lawyer must be given in the form of a notarial deed or by an oral statement of the party at the hearing before the court. The power of attorney must be given before the hearing of the cassation and not after. Legal aid is also available before the Supreme Court. A cassation proceeding in principle does not follow the rules governing the process of the trial at first or second instance. The lawyers of the party have the right, upon a request, to plead orally at the hearing before the Supreme Court, but this is not something that actually happens in practice. Certain provisions of the code aim to safeguard the right of the parties to be heard, including in cassation proceedings, and to ensure that the hearing of the cassation will take place even if the parties are absent. Cassation is the last resort within the Greek legal order. It's therefore extremely important that the appropriate provisions are applied in the proceeding before the court, in particular those relating to principles such as the right of judicial hearing and protection. Article 573, Paragraph 1 of the Code regulates the proceeding of cassation itself. It provides a certain list of articles of the second book of the Code on the proceeding before the courts of first instance, which also apply in the cassation proceeding. According to the legal theory and the established case law of the court, the list is indicative and not restrictive. Articles, for example, Article 236 on the judicial duty for guidance, despite being a provision of the proceedings of the courts of first instance, it may be applied by the Supreme Court whenever it ascertains that the ground for cassation is articulated incompletely. Moreover, in the event of inconsistent grounds of cassation, the court may invite the petitioner to waive one of the inconsistent grounds. Another example are provisions on interruption and retrial of the case because, for example, of the death of a party, ways of abolition or termination of the trial, withdrawal from the filed cassation, waiver, compromise also apply in the cassation proceedings. Furthermore, the general provisions of the first book of the Code also apply to the cassation proceedings, provided there is no special provision in articles regulating cassation, and that those general provisions of the Code are not contrary to the nature and the characteristics of cassation. In this context, the Supreme Court has held that, for example, provisions such as for guarantee for court costs or challenge of a judge are also applied in the cassation proceedings. Despite the fact that some provisions of the Code are not mentioned explicitly in Article 573, Paragraph 1 of the Code, they do apply in the cassation proceedings according to the prevailing opinion in the Supreme Court's case law. One example is Article 249 on the suspension of the trial in cases where the adjudication of the case depends on another issue pending before another court. Finally, and I'm going to end with this, another notable issue is the application of certain provisions, for example, Article 67 and 227 of the Code, which are not mentioned in this specific article on the cassation proceedings, are both concern the opportunity of the parties to remedy formal omissions after the hearing if the Supreme Court asks them to do so. For example, to submit the necessary power of attorney which is missing from the file, or to remedy other issues related to their legal representation. The plenary session of the Supreme Court has recently held its decision number 13 of 2018, plenary session, majority opinion, that Article 67 of the Code applies also to cassation proceedings, so the Supreme Court may set a deadline for the party to comply with its directions and to submit the appropriate document. It is important to note that in this judgment, the court describes a model of proceeding of the cassation and in general, a model of a civil trial, which is not reliant on formalities. On the contrary, it is oriented to the actual adjudication of the case so that the dispute can be resolved in any effective and quick way. Thank you so much for this opportunity.
Thank you very much, Anna. Thank you so much. It would have been very interesting, however, to tell us a few things about the Supreme Court of Cyprus, but okay, it's not in the agenda today. Now I would like to give the floor to Anastasia Vezyrtzi, Dr. Anastasia Vezyrtzi. Please,
Thank you,
Anastasia, first.
Thank you, Professor Glavinis. It is also my great pleasure and honor to participate in the conference among such distinguished professors, and I would like to thank Professors Makridou and Diamandopoulos for having given me such opportunity. The goal of my intervention is to frame the procedural safeguards that need to be fulfilled in order for Aristotle to be allowed to invoke and examine certain cassation grounds ex officio under Greek law. From a comparative perspective, the French Code of Civil Procedure explicitly allows in Article 620, paragraph 2, the French Cour de Cassation to raise arguments sua sponte. However, according to Article 1015, the fundamental right to adversarial proceedings must be respected by the court itself, which should give to both parties the opportunity to reply to the new arguments envisaged. Procedural due process concerns in relation to sua sponte decisions are addressed also by American doctrine and jurisprudence. As Justice Scalia has emphasized in United States versus Burke, the rule that points not argue will not be considered is more than just a prudential rule of convenience, as it distinguishes the adversary system of justice from the inquisitorial one. One method often endorsed by the Supreme Court is to request supplemental briefs and additional oral argument when it raises an issue sua sponte. An interesting ruling was also that decisions in which the opinion was rendered without full briefing or argument have a lower precedential value. Under the perspective of Greek law, the ability of Aristotle to raise certain cassation grounds ex officio was introduced in the Code of Civil Procedure of 1968 as amended by the legislative decree of 1971. The objective of the legislator as depicted in the explanatory report was to serve the administration of justice, as it is not right to leave an incorrect legal decision intact because the appropriate ground for cassation has not been proposed by the litigants. The current Code of Civil Procedure provides such authority in paragraph 4 of Article 562. The cassation grounds that fall under the scope of the provision are exclusively specified and are 6 in total. According to the wording of the provision, the specific grounds should be examined ex officio on an exceptional basis. However, it cannot go unnoticed that under its scope fall some of the most frequent and significant grounds of cassation as that of lack of legal base. In addition, it should be clarified that in order to apply paragraph 4, Aristotle shall find the cassation appeal admissible along with infringements in the attack decision that fall under the special cassation grounds depicted in paragraph 4. Before Law 4335 of 2015, the reporting Supreme Judge could propose in his report some grounds which could be examined on the Supreme Court's own motion. According to Greek jurisprudence, there was no violation of the right to a fair trial, as the report ought to be filed with the court at least 8 days before the hearing and was accessible to all parties who were permitted to present their views on the matter. After the amendment of 2015, the role entrusted to the reporting judge was limited, and as a consequence, his report was no longer a prerequisite in order for Aristotle to be able to advance the specific grounds on its own motion. Greek legal theory pointed out from the very beginning the flagrant violation of the right to a fair trial, as parties were no longer given the opportunity to comment and lay out their views. Despite the expressed concerns, Aristotle didn't hesitate to apply the provision in order to either invoke a new cassation ground or supplement an already proposed one. However, recent amendment of paragraph 4 by Law 4842 of 2021 provided stronger due process protections, as cassation review is permitted only if Aristotle informs the parties for the new grounds envisaged and gives them the opportunity to submit their comments. Moreover, it is explicitly declared that the court can pronounce a judgment only after the given time period for additional submissions has expired. As stated in the explanatory memorandum, the pursuit of the legislator is to prevent any violation of the right of a trial, to safeguard litigant parties to be right to be heard, and to avoid putting parties in front of surprises. It is also important to note that the new provision as amended is also applied to cassations already filed, which shows the strong willingness of the legislator to give end to any potential infringement of fundamental rights. To sum up, the incentive for adopting Article 562, paragraph 4, a provision clearly in favor of the party initiating the cassation proceedings, was the pursued goal not to leave an incorrect legal decision intact. This inequality is counterbalanced with Article 578, which functions in favor of the party against whom the cassation proceedings have been initiated. More specifically, if the case has been decided correctly, but there is a violation of the applicable law in the opinion of the judgment, then such error is disregarded and the cassation is dismissed, although the proposed ground may be well-founded. The reasoning behind this provision is to leave intact a correct, this time, legal decision. A critical point, though, regarding its function is that according to the prevailing view in Greek jurisprudence, arispagos is allowed not only to dismiss the cassation, but also to change the major premise of the judicial syllogism by including the correct rules of law, while using consequently in the minor premise those proven facts that are essential with regard to their subordination to the applied rules of law. Despite the fact that the actual decision remains intact, the issue whether parties' right to a fair trial is infringed arises again, as litigants are not informed and cannot submit any comments to debate the ex officio replacement of the erroneous part of the judgment. The conclusion to be drawn is that ex officio consideration of cassation grounds is more a question of administration rather than one of power. The reason is, according to my opinion, that the power itself may be clear, but the real problem is when it should be exercised. Therefore, every judicial system should redefine the objectives pursued through implementation of court's ex officio authority, while considering at the same time procedural safeguards for the parties' right to a fair trial. Thank you very much for your attention.
Thank you, Anastasia. Indeed. Before giving the floor back to the organizers of this conference, Professors Makridou and Diamandopoulos, I would like to ask our French colleagues, Professors Ferrand and Meyer, whether they have anything to say, any reactions to what they have heard. Any comments?
Maybe just a short reaction to what Anastasia just said. In fact, it is also stated in our French CPC that when the Court of Cassation contemplates a possible cassation ground sua sponte, it has, of course, to inform the parties, and they must be given opportunity to present their observations. The same applies when the Court of Cassation, for example, would like to dismiss the appeal in cassation on a cassation ground which was not raised by the parties, what we call rejet par substitution de motif, for example. And this is, of course, due process clause. And I think it's very important that the parties are given this opportunity to present their observations.
Thank you, Professor Ferrand. Professor Meyer, peut-être auriez voulu faire un commentaire? Okay, so I will now give the floor to the organizers for the conclusions. Professor Makridou.
Thank you, Mr. President. Ladies and gentlemen, our rapporteur shared with us their experience and their expertise on the main features of the two systems under Greek and French law. Professor Ferrand and Professor Delikostopoulos presented the distinction between facts and law, which is one of the most complicated issues in civil procedure. Professor Meyer and Professor Tsikrikas presented the aim of cassation and the conditions of its filing. I'll make an effort to focus on the most important features, trying to compare the two systems. So cassation, as we said, under Greek law has been modeled on French law, and therefore the similarities are inevitable. In both legal systems, one single court, la Cour de Cassation in France and the Aristotle in Greece, is entrusted with a review of the judgment restricted to points of law. The Court of Cassation cannot assess the evidence. This was obvious from the presentations, and cannot also review the findings of the facts. As all rapporteurs clarified, the essential function of the Court of Cassation is to secure the correct application of the law and to ensure the unity of interpretation of legal rules. In both countries, lower courts are not obliged to comply with the lines set by the highest court, despite the fact that they tend to. In relation to cassation grounds, the two legal systems have both similarities and differences. While the Greek Code of Civil Procedure provides for a list of 12 exclusively specified cassation grounds, the French Code of Civil Procedure implicitly refers to the existence of several cassation grounds that are, however, mentioned neither in the Code of Civil Procedure nor in the Code of Judicial Organization. As Professor Ferrand pointed out, the absence of an official list of cassation grounds allows flexibility on the part of the court. The cassation grounds that were presented were all based on a violation of the law in the broadest sense and were rather similar with the ones indicated under Greek law. Characteristic example is that the ground of cassation termed manque de base légale, it's the lack of legal base, which has been introduced in Greece under French influence. Another difference that emerged from the presentations of Professor Ferrand and Tsikrikas is that while the Cour de Cassation does not review whether a legal rule applied in the case at stake complies or not with the French Constitution, the plenary session of Areospagos has such a competence. Appeal in the interest of law, dans l'intérêt de la loi, is among the common features of the two legal systems. As Professor Tsikrikas explained, under the influence of the French model, the Greek Code of Civil Procedure grants the public prosecutor of Areospagos the authority to act as a party and file a cassation, which does not affect the parties. The res judicata effect of the decision by the court below remains binding on them, unless cassation was founded on the exceeding of jurisdiction or the lack of subject matter competence. While under Greek law, parties have no legal interest to intervene in the proceedings, since they won't suffer the effects of a possible cassation, on the contrary, under French law, Professor Meyer underlined that adversarial debate is thought to be a benefit of the court. Parties are therefore also presumed to have a legitimate moral interest in defending the decisions they obtained. On the rather complex issue of the distinction between facts and law, our rapporteur, Professor Ferrand and Professor Delikostopoulos, focused on the legal characterization of the facts and the scope of the review. Professor Ferrand presented the several tendencies which lead either to reduction or to an extension of the scope of the review. A characteristic example of reduction is that deriving from a new rule formed by the case law of the Cour de Cassation called Principe de Concentration des Moyens. According to a famous judgment of July 2006, res judicata prohibits the claimant from starting a new lawsuit and invoking a legal ground which he or she had refrained from raising in good time. Professor Ferrand presented with clarity all the cassation grounds. Some selected remarks related to their scope of application are the following ones. First, that the Cour de Cassation itself may raise the lack of jurisdiction ex officio if the case falls within the jurisdiction of criminal or administrative courts, or if the case has to be brought before a foreign court. Second, that the lack of legal basis may give rise to numerous appeals in cassation. It is clear, though, that the extension of review to the sufficient quantity and quality of the reasons provided in the challenge judgments led to a closer look at the facts of the case. From a Greek point of view, Professor Delikostopoulos clarified that the court's assessment of facts and the evaluation of evidence, as well as the content of documents, are not subject to the control of Areospagos. Referring to the distinction between questions of facts and questions of law, he pointed out that it runs both ways, as on one hand it allows for a certain degree of control by the Supreme Court, and on the other hand it produces limits to the exercise of this control. Our rapporteur presented on a case-by-case basis what is reviewable and what is not reviewable in cassation. Part of the presentation was also dedicated to the specification of vague legal concepts. By way of conclusion, regarding the evolution of control exercised by the Aristotle, Professor Delikostopoulos emphasized that a successful institution is the one that refrains from doing more than what is truly necessary, bearing in mind that the end result is the creation of a system of law. Having pinpointed the missions of cassation, Professor Mayer highlighted the contemporary debate on the existence of hierarchy between them, attached to the vigorous debate on the nature of the power of the Cour de Cassation. To the question posed whether the Court of Cassation has the power to create norms, our rapporteur answered that its decisions do have a normative impact, but they do not set down general and abstract rules of law. Both our French rapporteurs were rather skeptical regarding the debate on the proposed selection of appeals for cassation, as it would result in a breach of equality between citizens before the law and justice, along with a decline in the quality of decisions on the merits rendered by the lower courts. As it was underlined, instead of the implementation of a selection system, the idea of differentiated paths to appeal prevailed in the end. Similarly, under Greek law, a certain path is provided in order to avoid overloading of various powers and secure its function to protect legal norms. Professor Tsikrikas explained that a pre-trial examination of the cassation and its grounds by a special judicial council leads to the cancellation of the hearing when cassation is evaluated as inadmissible or manifestly ill-founded. Finally, under the umbrella of the general topic, Assistant Professor Anna Plevri and Dr. Anastasia Vezyrtzi referred with their comments to two special topics. The first one presented some selected issues of the cassation proceedings, while the second one dealt with the power of the Aristotle to invoke certain cassation grounds ex officio. Ladies and gentlemen, now that the conference is over and before giving the floor to the President to close the conference, I would like to thank our distinguished rapporteur from France, Professor Ferrand, Professor Mayer, who honored us with their contribution, our friends and colleagues, Greek colleagues from the Law Faculty of Athens, Professor Tsikrikas and Professor Delikostopoulos, and also Dr. Vezyrtzi and the Assistant Professor Anna Plevri with their comments. We really hope that the conference achieved the main aim that it had to present a comparison between the two systems, the French and the Greek one. Let me finish with one key conclusion that derives and has to do with a French, very famous French expression that the judge should be the mouth of the law, la bouche de la loi, which I think is not depicted, does not depict the cassation regime. Thank you very much.
Thank you so much, Professor Makridou. Before giving the floor to Professor Diamandopoulos to conclude with a few words this conference, I want to thank all the speakers for their outstanding lectures, actually. They shed light in a few minutes on very interesting aspects of the control exercised by the Supreme Court in both jurisdictions, Greek and French, over judgments of lower courts. We also need to thank our editor, Sakulas Publications, for having hosted this conference. George, perhaps you want to say a few words?
The conclusions were common. I would also like to thank all of you for your participation and of course our audience for its patience. I promise that the 6th volume will be edited till next month. So we are going to see you again, we hope, in 2 years' time. Thank you very much, all of you.